So the ruling today that came out just about half an hour ago, I guess, from the Quebec Court of Appeal on the constitutionality of Bill 21, pretty much a win across the board for the Quebec government, and that includes, as far as it concerns, the English Montreal school boards and English school boards in general here. Joe Ortona is chair of the EMSB and is on the line. Joe, thanks for taking the time. I know you were waiting for this today and obviously expected a different decision, so first of all, just give me your reaction.
Well, it's a tough day for us. We're obviously disappointed with the result. It's not the result that we were hoping for. So it's kind of tough to swallow right now. But look, we're going to have to take the time to read this decision in full before we can make a decision on where we go from here and what the next steps should be.
So the next step, I mean, we knew, regardless of what the decision was going to be today, whether it had been the EMSB or Canadian Muslim Association, whoever took this this ended up in this with the challenge originally, would probably end up at the Supreme Court of Canada. Had it been the other way, we were pretty much guaranteed that the Quebec government would do the same. So you say you need to study this. Is part of the thinking now that after you've kind of been handed this ruling today, that would just be a waste of time and or money, or not?
Well, look, I mean, we have a judicial process, and included in that is an appeals process. So that's what the Supreme Court of Canada is there for. There's only one factor here really to consider. The lawyers have read the decision in full this afternoon. I've only been advised of the final decision. So the question now is, are there grounds to appeal and what the chances of success are? And ultimately, that's what a decision, whether you appeal, should be based on. And so we're going to have to take a look at that, give it serious consideration, and then make a decision accordingly.
So if you could, for people listening, explain what this does mean now by virtue of the fact that they have said, no, you don't get special status here. You don't get to basically go ahead and hire these teachers who you want to, who can wear religious symbols. Is that the extent of it?
It is, which was the extent of the law when it passed, and the Superior Court judgment, because the government appealed, didn't change the status of the law. So it really doesn't change anything for us right now. It's status quo, the way it's been since the law was passed in 2019. It's disappointing, but that's what the situation is.
So this is Bill 21. We had Kelly Gregg on from CTV. I kind of confused for a while Bill 40 and Bill 21. This is a direct ruling as far as Bill 21 goes. With respect to Bill 40, though, what changes? And I asked that, Joe, because it seems to me in the judgment, at least the part that I've been able to sort of read and understand, is that this Court of Appeal unanimously said that the use of the notwithstanding clause preemptively is okay in these cases, which might lead you to believe that they'll have the same ruling when it comes to Bill 40.
No, it's important to understand that the notwithstanding clause cannot be invoked for Section 23 of the Charter. So when we're looking at Bill 40, the notwithstanding clause has nothing to do with anything. In fact, I didn't invoke the notwithstanding clause for Bill 40 because the government cannot. So the notwithstanding clause was really arguments that were used for other challenges, namely, gender equality, freedom of religion, and those kind of things, for which, unfortunately, the notwithstanding clause can be invoked. So the government can never use the notwithstanding clause for any legislation against English language school boards.
Okay, and I hope that's in fact the case. One always remembers never say never. This government has a habit of doing things we didn't expect to begin with. What is the status then with respect to Bill 40? What happens next in this?
Well, the government decided to appeal that, and that appeal will, I guess, eventually be heard in the next coming months, hopefully. Look, we got a sweeping victory on Bill 40, so we remain confident that that decision will be ultimately upheld.
Okay. Did you have, I know you've been, a lot of people obviously been anxiously waiting for this decision today. Did you think, I'm going to ask you just basically what you would expect today. Before you heard this, were you thinking you had a good shot at winning this?
Look, it's very difficult to tell in these kind of cases. The judges they asked questions, sort of played devil's advocate on both sides. They were very difficult to read. So you never know ultimately what is going to be decided. Like I said, it's disappointing. The decision, I think, could have ultimately gone either way. The judges today decided that the government was right and we were wrong, and That's disappointing. And as I said, though, that's not necessarily the end of the road. We have to look at what our options are and what our chances of success would be. And ultimately, if there are grounds to appeal, then we should appeal. And that's how I feel.
I would ask, some people pointing out, by virtue of the fact that it was unanimous, right? All three judges basically agreeing on this one, that sort of gives you the indication that maybe you have less grounds perhaps in that case. Had it been a split decision, that might be different. Do you take that into account?
No, I think it's the merits of the arguments and what motivates the judges. There are over 20 judges at the Court of Appeal. We just happen to have 3 that heard the case. I mean, different judges sometimes view things differently and rule differently. So that's what the Supreme Canada is there for. It's there to settle matters once and for all. And again, we're going to have to look at what our options are, and we'll be able to decide that accordingly, and do that relatively quickly. Because as I said, our lawyers read the judgment in full this afternoon, so they'll be able to brief us very quickly.
Okay. With respect to what it does mean for you, for the English Montreal School Board, and I asked this question as well earlier on, it's not about teachers you already have in the system who do, in fact, wear whatever they wear to class, whether it's a hijab or any other visible religious symbol. They get to stay. Nothing changes for them, right?
Correct. So the grandfather clause that was in Bill 21 continues to remain in effect. So teachers or principals who were wearing religious symbols in 2019 get to continue to do so, yes.
Okay. It would mean that you cannot, obviously at this point, and this becomes effective as of the ruling, that you cannot hire more teachers like that even if you wanted to, right?
Well, it's been effective since the law was in place. That's why I say, that this judgment really, it doesn't change anything in terms of what the status of Quebec law is, because when the government appealed the initial judgment in Superior Court that we got in our favor, it suspended that decision.
Right,
so
okay.
We haven't been able to hire teachers, unfortunately, who choose to wear a religious symbol since 2019. So the judgment just basically confirms that, and that's the status of the law moving forward.
I wonder if it's an odd thing to ask, if teachers already in the system who were hired, right, who were allowed to be hired at one point, look at the decision like this and say, you know what, this is wrong and it shouldn't be this way. You have a concern that some of them may consider leaving?
I don't know. I guess, that's a personal decision. I would say to any teacher who's disappointed by this judgment, to hold their head high. This isn't necessarily the end of the road, and to continue to do the good work that they're doing. And they shouldn't give up so easily. Sometimes losses are tough to handle, but the sun will rise tomorrow, and this isn't the end of the world.
Okay.
So we'll see where we go from here.
Joe, thank you so much. Appreciate you taking the time.
Thank you.
All right, Joe Ortona, chair of the English Montreal School Board, and yes, they lost today by virtue of that Quebec Court of Appeal ruling, but as he said, this may not be the end of the line. He also said, interesting to note, that when the lawyers for the EMSB looking over this decision basically take the time and figure out what to do next, it won't take long to figure out whether there will be an appeal here or not. Found that interesting.